Hi everyone, this is John Khosravi of the JQK Immigration Law Firm. Today I'm going to do a recap of the new National Interest Waiver Standard, also known as the EB-2c or NIW Green Card. Please note that this is not legal advice. I'm simply going to overview the legal standard. Each case requires its own analysis, so if you're interested in using this visa category, please consult with a business immigration attorney about your case and your background. Who can use the National Interest Waiver, NIW? The NIW is under the EB-2 category and can include researchers, scientists, professors, technology workers, coaches, corporate leaders, engineers, entrepreneurs, musicians, and even more professionals based on the new NIW standard, including startup founders. Essentially, the applicant needs to show that they and their work is in the national interest of the United States. The National Interest Waiver is a great visa category, especially for those that are skilled immigrants. It permits a waiver of the job requirement of other green card categories, and you could request it on your own without having an employer or an agent or a separate petitioner. But how do you prove you and your work are in the national interest to obtain this green card? Well, in the past, there was an old standard called the NIW standard. It was vague and allowed subjective judgments of adjudicators and created a lot of problems for beneficiaries and applicants. However, the legal regime and framework for analyzing national interest waiver cases just changed. On December 27, 2016, as a Christmas present from the Department of Homeland Security, the new Don-Assar framework was established. The Administrative Appeals Office, known as the AAO, acknowledged the shortcomings of the previous NISDOT standard and tried to provide clarity and more flexibility in the NIW standard to benefit the United States with top-level immigrants. The first level of analysis for the EB-2 NIW category is that an immigrant has to be a member of the professions holding advanced degrees or their equivalents, or who because of exceptional ability in the sciences, arts, or business will substantially benefit prospectively the national economy, cultural, or educational interests or welfare of the United States. The second level of analysis for the EB-2c category is based on this new Don-Assar standard. Under the new progressive standard, the petitioner must demonstrate by preponderance of the evidence that 1. The foreign national's proposed endeavor has both substantial merit and national importance, 2. That the foreign national is well positioned to advance the proposed endeavor, and 3. That, on balance, it would be beneficial to the United States to waive the requirements of a job offer and thus a labor certification, which is normally required for other EB-2 categories. Now let's break this down and look into this rule with a little more detail. The first prong focuses on the specific merit and the scope of the endeavor, the activity the immigrant would do and proposes to undertake in the United States. We could break the first prong into two sections. First, the merit. Merit can be demonstrated in a range of areas such as business, entrepreneurialism, science, technology, culture, health, or education. Evidence that the endeavor has the potential to create a significant economic impact may be favorable, but is not required. Merit can be established without immediate or quantifiable economic impact, such as those related to research, pure science, and the furtherance of human knowledge, whether or not the potential accomplishments in those fields are likely to translate into economic benefits for the United States. Now, part 2 of this first section is national importance. And national importance can be determined by potential prospective impact, meaning the impact the work can have on a larger scale in the United States and globally. Now, you can have national or global implications within a particular field, such as those resulting from certain improved manufacturing processes or medical advances, but it's not solely evaluated anymore based on geographic terms. Broader implications are looked at. Even ventures and undertakings that have as their focus one geographic area of the United States may properly be considered to have national importance. An endeavor that has significant potential to employ U.S. workers or has other substantial positive effects, particularly in economically depressed areas, for instance, may well be understood to have national importance under the new standard. Now, moving on to the second prong of this three-prong test, is the immigrant well positioned to advance the proposed endeavor by considering factors including but not limited to the individual's education, skills, and knowledge, record of success in related or similar efforts, a model or plan for future activities, any progress towards achieving the proposed endeavor, and the interests of potential customers, users, investors, or other relevant entities or individuals. It does not require petitioners to demonstrate that their endeavors are more likely than not to ultimately succeed. And finally, the third prong, demonstration that on balance, it would be beneficial to the United States to waive the requirements of a job offer. This can be done by evaluating such factors as whether, in light of the nature of the foreign national's qualifications or proposed endeavor, it would be impractical either for the foreign national to secure a job or for the petitioner to obtain a labor certificate, whether, even assuming that other qualified U.S. workers are available, the United States would still benefit from the foreign national's contributions, and whether the national interest in the foreign national's contributions is sufficiently urgent to warrant foregoing the labor certification process. I'd love to discuss this more in detail and learn more about your case. If you are interested in scheduling a consultation, please contact my office, John Q. Khosravi Immigration Law Firm, at 310-582-5904, or email me your resume or CV to info@jqqlaw.com. I look forward to hearing from you.